Welcome back to Legislation Daily. Let's explore the concept of basic theft in the UK. Theft is a key offence under British law, primarily governed by the Theft Act 1968. The legislation provides a comprehensive definition of theft and outlines the conditions under which an individual can be found guilty of this crime. According to Section 1 of the Theft Act 1968, theft is defined as the dishonest appropriation of property belonging to another with the intention of permanently depriving the other person of it. This definition incorporates several key elements. Dishonesty. Section 2 of the Act provides guidance on what constitutes dishonesty. While the Act does not exhaustively define dishonesty, it includes situations where the defendant knows they have no legal right to the property, or they are aware that the owner would not consent to the appropriation. Appropriation, under Section 3, refers to any assumption of the rights of the owner of the property. It includes actions such as taking, using, selling, or destroying the property. Even if the property is obtained lawfully, subsequent actions can still constitute appropriation if done dishonestly. Property. Under Section 4 of the Act, property includes money, physical goods, personal belongings, and intangible assets like patents. The definition is broad, covering anything that can be owned or possessed. Belonging to another, Section 5 clarifies that property is considered to belong to anyone who has possession or control of it, or who has any proprietary right or interest in it. This means that even if someone is not the legal owner, taking property from someone who has a right to it can still amount to theft. Intention to permanently deprive. Section 6 specifies that the defendant must intend to permanently deprive the owner of the property. This can include situations where the defendant treats the property as their own even if they plan to return it later. Theft is classified as an indictable offence, meaning it can be tried in either the magistrate's court or the Crown Court, depending on the severity of the case. The maximum penalty for theft under the Theft Act 1968 is 7 years imprisonment. However, sentencing will vary based on factors such as the value of the stolen property, the defendant's intent, and their criminal history. In addition to simple theft, the Theft Act 1968 also covers aggravated forms of theft, such as robbery, which is theft involving violence or the threat of violence, and burglary, which is theft involving unlawful entry into a building. The Theft Act 1968 establishes a clear legal framework for dealing with theft in British law. The key components: appropriation, property belonging to another; dishonesty, an intent to permanently deprive, are critical in determining whether an act constitutes theft and what penalties may apply. Thanks for watching. Don't forget to like and subscribe.